So you are the only female between us. What if we appointed you as the presiding member?
I mean, it makes no difference, but sure.
What do you think, Ivan?
Yeah, I think it's a very good option.
Very good.
Inclusive.
Smart, very smart.
So the floor is yours.
Oh, perfect. Can I just check with the Webnyay team if we're good to go?
Yeah, 2 minutes. After 2 minutes, we can start.
Okay, we wait for 2 minutes. All right.
Yeah, I'll tell you when to start.
All right.
Do we ask them to open the camera or not? I don't know the rules about this.
Well, I just came out of one round just now, and yes, I think at least the participants definitely should have their camera on.
Very good. At least you can see their.
Yeah.
Yes, that's much better. I will show you my face as well. Great.
Yes, we can start.
I just saw that Ivan had left. Can I just check that he's back again?
I have again problems, so I need to rejoin. Left and rejoin again.
Okay. All right. Great. Okay. So should we start then?
We are ready to go.
All right. Great. So may I then invite the claimants, senior counsel, to take the floor? Do we have claimants here?
Damianti, I have a quick question for you. Who is taking care of the watching the time? Do you have some? No?
That's actually a very good question.
Yes, we need.
May I ask if the page, can you help us with that?
What do you need help with?
Just to keep a watch on the time, because I understand that both teams have 45 minutes each, right?
Exactly.
Yeah, I'll keep just whenever someone is speaking, they can tell the time that they'll be taking, and I'll keep the count of it.
Perfect.
Thank
Perfect. Can I ask if the claimants are ready to start then?
Yes, Your Honor.
Okay, so should we start, please?
Your Honor, can we have some time? Like, we have difficulty with the mic.
Oh, okay. All right. No problem.
May it please Your Honor, my name is Anija.
and I appear for the appellant in this action, along with my learned senior counsel, Ms. Raifa. Is Your Honor sufficient familiar with the facts of the present case?
Yes, I am, unless my co-judges want to hear the facts. I think you can proceed.
Go ahead, Zenia.
I think there are some technical issues.
To save the time before this start, I just want to confirm I am visible and audible properly, right?
Yes, you are.
Hello, am I audible?
Yes, we can see and hear you.
Hello?
We can hear you. Can I suggest to try something? Maybe the judges and the participants who are not speaking will turn off their cameras, because if the internet is very low at the side of the claimants, maybe this is the reason why she's unable to speak. Let's try.
Hi, Anija, are you on call? Can you hear us? I request you to please unmute yourself. Hi, Anija, can you hear us?
Am I audible?
Yes, we can hear you.
We can hear you, yes.
Yes, okay. Okay, I'm sorry for the delay. I'm so sorry.
No problem.
May it please Your Honor, my name is Anija Roji, and I appear for the appellant in this action, along with my learned senior counsel, Ms. Raifa. Is Your Honor sufficiently familiar with the fact of the case?
Yes, please proceed.
Alright. So the first issue will be dealt with my senior counsel, Ms. Raifa.
May it please the court?
Yes, please proceed.
Artemis' headache was not the main reason for the mission failure. Solar Dream owed a duty of care to ensure the safety of its passenger, including proper medical evaluation and adherence to the safety protocols. Artemis has been experiencing head pain for the past 5 years and has been seeking medical attention. However, her condition is considered normal, so she did not include it in the list of symptoms. And Solatrine's specialized doctor approved her medical safety for space travel, and she paid half of the payment. And in the eighth point, it states that she was given a declaration stating that she had no medical condition or symptoms that could affect her ability to participate in the space. In the sixth point, Artemis was convinced her headache were caused by a misalignment of her neurons with the Earth's gravitational field. Which could be corrected through meditation, low gravity. She believes she is physically and mentally fit, and that her chronic headache will not prevent her from participating in the star alignment. So there is no breach of contract because, to the best of her knowledge, she is physically and mentally fit. According to the ninth point, she was quarantined for 2 weeks, and she experienced severe headache during the second week. Why couldn't the medical professional recognize the changes? During the headache, some chemicals in the brain become more active, which can be identified through CBC or MRI. So, if the medical professional performed these tests, they could have easily find out the headache. CBC and MRI scan are commonly performed on astronauts before they go to the space as part of their pre-flight evaluation. These medical assessments are crucial for ensuring the safety and well-being of astronauts during their mission. So it is clear that Solar Dream medical professionals failed to conduct these tests, and they only did some basic checkup, which is not accurate. Also, there are certain clues and indicators that could medical expert may observe in a chronic headache. During a physical examination, a medical expert may discover signs include soreness in certain parts of the head or neck, changes in pupil size, sensitivity to light, or abnormalities in the optic nerve. And second, observational clues. These people will avoid bright light and loud noise. Why didn't the medical professionals notice these all? And the doctor who conducted the examination was a retired chief medical officer of NASA. All the lateral flow tests, including Artemis test, came back negative, and she waited for the result of her PCR test. But they informed her that due to a lab delay, the test result would take longer, and the window for the launch was likely to close due to a meteorological condition. So Solar Dream decided to take off before receiving PCR test result. Because all lateral flow tests showed negative result, and the nurse on the duty advised that a lateral flow test was sufficient, and this advice was given by a nurse. Why couldn't they just ask to the doctor as well? Because the nurse who conducted the examination on the day of departure was hired on a short notice from a local outsourcing company in DIFC. Therefore, this is completely medical negligence. Sending parties to space without even having a PCR test can't be considered fair. The main issue here is that Artemis COVID is positive, and that retreat has been cancelled. Her chronic headache is not a symptom of COVID-19 because she has had it for the past 5 years, while COVID began in the 2024. Solar Dream's medical professionals failed to understand her severe headaches, and Solar Dream personnel decided to light take off before receiving the PCR test result was negligent on the side of Solar Dream. The companies owes a duty of care to the passenger, and as a result of the breach, the passenger and crew member got COVID. Solar Dream failed to adhere to the neighborhood principle. That's all, Your Honor.
Can I ask questions?
Yes, Your Honor.
I have actually two questions. So basically, why she didn't disclose? So you said, oh, it was a normal state for her, the headache, the continuous headache. However, if you look at the facts of the case, it is clearly stated that she decided not to disclose because she was afraid she would be not a part of the space mission.
even if she is not described, it is the duty of Solar Dream to conduct a thorough medical assessment. Why did they do that? To ensure that passengers are physically and mentally capable of ensuring the rigors and space travel. And Solar Dream failed to do these duty of care.
I agree, but this is like what we will discuss in the future. However, like if you participate in the sports events or in other trips or that require certain medical fit, it's also shared responsibility between yourself and their launch company. You cannot shift everything. You cannot shift everything on the receiving party or a contracting party, because you have to disclose information from your end. And you must agree with me that it's much more difficult to deal with a participant of the space mission if the medical information is not properly disclosed.
Your Honor, Artemis is a participant. Like, she is doing this for the first time. She is not aware of the rules and regulation. Therefore, the Solar Dream, it's their duty to disclose, like, what are things they have to send. Like, it's their duty. They have to make them to do those like documents.
Counsel, sorry, pausing you there, and to just add on to what my co-judge said. In the contract that your client signed with Solar Dream, wasn't it your client's duty to disclose all her medical conditions? Maybe irrelevant, but was it not her duty to disclose?
Your Honor, according to Artemis, she believes she is physically and mentally fit, and that chronic headache will not prevent her from participating in the star alignment. It is clearly written in the 6th point. So how can she say that this headache is a symptom of this thing?
So, is it your position, if I understand it, that simply because your client, who is not a medical professional, believed that if the headache was not relevant, she was not under a duty to disclose that medical condition?
Your Honor, can you please repeat the question?
Is it your client's position that even though she's not a medical professional, simply because she believed that the headaches that she had were not relevant for her to be told to Solar Dream, she did not need to disclose that to Solar Dream?
Your Honor, Solar Dream specialized doctor approved her medical safety for space travel, and she paid half of the payment, right? So she thought that she is medically and physically fit, because Solar Dream's specialized doctor also approved. So what else? And this doctor is a retired medical officer of NASA.
All right, thank you. Unless somebody else has any other questions.
Yeah, maybe a last question from my side. Do you have case law that supports your points of view that you've just shared?
Your Honor, while we do not have a specific case law to support our statement, our argument stands on its own merits based on the clarity of the issue at hand. It is sufficiently clear, and the law in this matter is well established and does not require further explanation through case laws.
Thank you.
Thank you, Your Honor.
Are we to hear from the defendant's senior counsel now?
Good afternoon, ma'am. Actually, the senior counsel just had some internet problem. He'll be coming within a while. Really sorry. He just joined.
Am I audible?
Yes, you are.
Can I start?
Yes, please.
Good morning, good afternoon, and good evening, everyone sitting around the different corners of the world. I am Shivam Agarwal, representing the team of Gujarat National Law University, Gandhinagar of India. Hope I am audible and visible properly. if I may be permitted to proceed. Greetings to the Honorable Court. Your Honors, I am the counsel appearing on behalf of the defendant, which is the Solar Dream in the present case. If you are permitted to ask any preliminary questions, I would like to describe the time allocation now. Your Honors, I will be dealing with the defense to the claim in the first 17 minutes and will reserve 5 minutes for the sir rebuttals. Similarly, my co-counsel Varma Sahu will be speaking regarding the counterclaim in the next 17 minutes and reserve the 5 minutes. We reserve the total 1 minute for the plus minus of the overall timings. Can I proceed with the arguments?
Yes, please.
Yeah. Just to brief your honors about the timeline of the incidences that happened in the present case, I would like to state 5 of the date lines. First date comes to the notice when 15th of February 2024 is the date which was originally scheduled for the Space Yoga Met. 10th February 2023 is the date when the Miss Claimant purchased the ticket for the Space Yoga Met. Then important date comes, the 1st February 2024 is the date when the claimant has come to Dubai with a layover in New York. This is the place where the quarantine was to be taken place, and this is the place where the claimant had the severe headache and she started suffering from the headache again, and she was feeling tired. So which is a change in the situation of the physical forms of the claimant. Next important date comes is 14th February 2024 is the date when the Solar Dream informed that they are ready to go. The green signal was given by the personally of the Solar Dream after checking all the medical situations and other relevant informations. The green signal by the Solar Dream was given. And the final date, which is 15th February 2024, is the date when the flight went off. If I may be permitted, the counsel in the due course of the submission regarding the breach of contract and tort would like to make submissions in 5 major points. 1, the duty of care and the standard of practice. Second, that the claimant already had the pre-existing conditions of headache and other situations. Third, the mitigation efforts by the respondents, which is the Solar Dream defendants. Fourth, about the damages. And fifth, about the reliance on the lateral flow test by the defendants. If I am permitted to move to my first argument, which is about the duty of care and the breach, it is the Solar Dream fulfills its duty of care by adhering the industry standards and following all recommended pre-flight medical protocols. The protocols included the cursory medical examination, lateral flow test, the PCR test concluded on the day of the launch. This approach aligns with the well-established principle of the duty of care. However, it was Miss Claimant who did not follow her duty. It was her duty to fulfill, according to the clause 5.2 and 5.3 of the agreement, to disclose the medical condition which she is already suffering from, which she did not. The counsel for the claimant already states that it was her headache and it was the duty of the defendant to check by MRI and CT scans that why is this that. But until and unless the Miss Claimant is not informing us about the headache she's suffering from, how can the respondent come to know about that she's having a headache? How are we responsible to check it through MRI or CT scan? We did our best. What are the medical standards according to the recommended practice for human spaceflight occupant safety? Clause 4.4.2, 4.4.4, 4.4.5, 4.5.2, which is the emergency situations. Even after the flight was taken, even after the space yoga mat started, and we came to know that the claimant has a COVID-19 positive, we did our best. We did whatever we could. In the fact, if I may bring your attention to the paragraph number 12 of the preposition, it says that the captain and the crew began to put in places whatever measures they could prevent further transmission of the variant. Looking at the conditions of the other participants, they asked passenger to wear mask. This again shows that the respondents were responsible enough for the safety of the other passengers, and gloves for the duration of the retreat. and the meditation in the US session went ahead without Artemis. So Artemis was quarantined again. So all the recommendation practice for the human space flight, occupant safety, were fulfilled by the defendant. Hence, the duty of care and the standard of practice by the defendant was completely fulfilled. But, however, the Miss Claimant's duty to disclose the medical condition which she is suffering from was not fulfilled by her. Moving to my second argument about the
Mr. Shivan, can you allow me to
Yeah.
interrupt you here?
Jonas.
Yes. Solar Dream
Honest.
didn't ask for or waited until the PCR tests have been established and they have, given the green light for the launch.
Correct.
Do you think this is not a failure from your parties?
Correct. If I may bring your honor's attention again to the paragraph 12, where the fact matrix states that Solarion's personnel decided to green light takeoff before the receipt of the PCR test result because all lateral flow tests had displayed a negative results, and the advice of the nurse on duty was that a lateral flow test was sufficient statistically to rule out any risk that the passenger had COVID-19. So it was the advice of the personnel that okay, the PCR test has been done, but the lateral flow test has been displayed negatively. Hence, for the green light was given. Again, for this similarly, if I may bring the attention of your honors to the clarification number, I just Yes, so it was the nurse who was medical personally already experienced in the medical field who suggested that the tests are enough, and it was statistically proven that these are the enough tests. Henceforth, delaying the flight because of the one test which was not covered. Otherwise, all the requirements, which is the requirement of the quarantine, requirement of the test, requirement of the medical test, requirement of the emergencies, which all of them were fulfilled. But just because one test, for which already one test was done, the second test, subsequent test results were not came out, and delaying the spacecraft for that was injustifiable. Henceforth, according to the suggestions given by the medical personnel, we decided to take off the flight.
Council, may I sorry, Mohammed, did you want to say something?
No, it's okay. Go ahead, please.
All right. Council, can I just please bring your attention to clause 5.1 of the agreement that your client signed with the claimants?
Your Honor. Yes.
Which says that the passenger agrees to undergo medical evaluation conducted by a qualified medical professional.
Correct.
Is it your case that your nurse was a qualified medical professional?
In response to this, Your Honors, I have an answer with the clarification number 6 of the clarification problem, which says that there were two medical examinations, and the second medical examination was only a lateral flow test. Correct. It was a flow test to determine whether the COVID test is positive or negative. The first initial medical examination, which included a physical examination by nurse, a cardiovascular assessment including ECG, a spirometry test, a vision test, a general physiology health requirement, all of these important tests were conducted by the doctor who conducted the initial examination was Dr. Leonora McCoy, the retired chief medical officer from NASA. So the initial medical examination and the evaluation, which was the important medical examination and the evaluation, was conducted by a qualified personal medical official. However, the subsequent test, which was only testing of the COVID-19, was conducted by the nurse who conducted the examination on the day of the departure. She was hired from a hospital, and she was also having an experience of 10 years, where the Emirates Airlines pilots already underwent their routine monthly medical test. Again, for this, if I may bring your honor's attention to third clarification of medical examinations, where there are two headings given: the test conducted by the doctor and the test conducted by the nurse. So, in the test conducted by the doctor, there is one more heading which states that a physical examination by the nurse. So, this test, subsequent test of the nurse, is already a subgroup of the test conducted by the doctor. So, we submit here that the only test for the COVID was done by the nurse. However, the main examination of the medical report was done by the doctor. So the test by the nurse is a subgroup of the test by the medical doctor, which was the main medical examination. Your honors have any further questions on this?
Yes, I have actually.
Your honors.
So she experienced a headache, and you've mentioned that it's in accordance with the industry standards that you don't need to do like a deep dive tests, etc. Can you give us some examples? Because obviously the client, your client, is not the only company engaged in the space tourism sphere. So what other companies like Virgin are doing in the similar cases?
Your honors, if the claimant, Miss Claimant, did not inform us about the medical condition which she is already suffering from, how is the respondent, how is my client responsible to undergo all the unnecessary medical requirements which the claimant for the counsel for the claimant is asking for, which is a MRI report or which is a CT scan. The general medical examination, which generally takes place according to the recommended standards, were already taken place.
Okay, okay, got it. Second question, maybe I missed something in the facts, but just remind me. The whole, let's say, cancellation of the travel was because of the headache or because of the positive PCR tests?
No, so the facts of the case are something like that. The claimant already was suffering from the headache for last so many years.
Okay.
And according to the agreement, she was supposed to disclose it whatever the medical condition she is suffering from. She did not inform it. We went through the standard medical checkups in between, and the flight went off. And in between, preceding to the flight was taking 1 month preceding, there was the COVID-19 second variant came out. So, had it been the situation that the claimant has already informed us about the headache she's suffering from and that the medical change, she started feeling tired, if she had informed us about these changes, we might have taken into a consideration for the further medical checkups. But because she did not inform us, and the first test for the COVID-19 came negative, we gave the green signal to the flight. The flight went off. In between the flight, the crew of the flight came to know from the subsequent medical test, that the claimant is a COVID positive. So after it went,
Council
it came
Shivan, I will interrupt you again here because I was going to ask you the same question that came from Mr. Ivan.
Your honors.
What was the main reason behind the cancellation? It was the headaches or the COVID-19 that spread to all the passengers?
It was the COVID-19 report which the claimant tested positive. But because the headache was not disclosed to us, she got the COVID-19 positive in between the flight. Had it been the situation that she has already informed us about the headache and the medical change in the feeling, that is the tiredness, there might have been some other situations we might have taken, but she did not disclose it. So this was the cause and this was the result. Result was the COVID-19, but the cause was she not informing us about the medical condition she's suffering from.
Counsel, I appreciate where you're coming from, but tell me something. As a spaceflight operator, do you have certain duties to ensure that the participants that you are taking on your flight are medically fit?
Your honors, if I may take you to the recommended practice for human spaceflight occupant safety, which is usually followed by my client, there are 6 points which I would like to bring to your attention. First is 4.4.4, which is health stabilization and medical planning. The point herein this says that implement procedures and process to prevent acute infectious disease from being manifested during flight, such as through quarantine and social isolation of flight crew and space flight
No,
participants.
no, Council, again, sorry, just to interrupt you. I'm not talking about COVID protocols. I am saying, should you not have checked whether the claimant had a pre existing medical condition which may have uh, made her unsuitable for this flight in the first place?
Your Honors, the headache which she was suffering from is not a disease which can be understood by a medical officer himself also, if it is not being disclosed. These are the medical conditions. Suppose if I'm having a throat pain, until and unless I come to know that I am having a throat pain. So this MRI checkup, CT scan, all of them are the unnecessary medical reports. We followed the necessary reports of the medical examination which we were supposed to follow is already given in clarification number 3. There were so many reports. We also have underwent the cardiovascular assessment. We went to ECG. We went to vision test.
Understood. Thank you, sir.
Yes. Can I move ahead to the next arguments?
If there are no further questions, then yes.
Yeah. Your Honors, if you do not have any further questions, any other judges, I may move ahead with the further arguments. Okay. So the next submission the council hereby would like to make on behalf of the defendant is about the mitigation of the efforts. So upon discovering that the misclaimant's positive test result, Solar took immediate steps to mitigate the spread of the virus, including mask and gloves mandates, isolation measures, and separate sanitization procedures. These actions demonstrate our commitment to passenger safety, similar to the efforts commended where carriers mitigation efforts are liable. So we were responsible for the other participants also, only because the claimant was not just only because the claimant did not disclose and this situation happened, we cannot compromise with the other participants we were taking to. So henceforth, the efforts taken by us, my client, were already good enough, which they already took, and they are according to the fulfillment of the recommended practice for the human spaceflight occupant safety. All the clauses for the isolation, medical condition, safety were fulfilled by my client. Henceforth, the mitigation efforts to overcome this challenge was completely on behalf of my client. The next question comes to is the point of damages. So Solar Dreams dispute the extent of misclaimant claim damages. The spaceflight agreement outlines a standard refund policy for various scenarios, including pre-launch cancellation by the passenger and launch cancellation due to unforeseen circumstances. This policy, along with the limitation on liability for the passenger illness due to the undisclosed pre-existing condition, will be the presented to the court. Furthermore, the agreement may not guarantee specific activities, alternative content creation opportunities likely existed for the misclaimant. Solar Dream acted reasonably and in within the industry standards. Misclaimant's pre-existing condition and her failure to disclose it are the primary causes of this whole situation. Solar Dream, which is my client in the present case, is respectfully submitting to request that the court dismisses misclaimant's claim and award compensation for damages caused by her breach of the space flight agreement to the client, that is the Solar Team in the present case. And I hereby submit my arguments. I can go for the questions if you have any, Your Honors.
Yeah, same. I have the same question as I've asked your colleague from the applicants or claimants side. What case law do you have in support of your arguments?
The first case law I have submitted is the Donogh versus Stevenson, which is a very famous case law which talks about the duty of the care and the standard of practice. The another case law is the New Zealand case of Walker versus Canterbury, which highlights that the patient's omission of relevant medical history can impact a healthcare provider's ability to uphold their duty of the care. The next case is my argument is supported by the Bolitho versus City and Country Aviation Limited. It is a UK case where a tour operator was not found negligent for relying on a doctor's clearance for a passenger with a pre-existing condition. Another case law I am relying on is Thompson versus the Southern Pacific, which is a very similar to our present case. It is the breach of spaceflight agreement potentially jeopardizing the health and the safety of the other passengers in the same flight. The other case is Ackert versus
It's
Canadian.
okay.
Yes.
It's enough. Thank you very much. Thank you. No more questions from my side, Miss President.
No more questions from my side either. Should we hear rebuttals on this, or would the claimants prefer to have their junior counsel first argue?
As a rebuttal, Your Honor.
Okay, all right, perfect.
May I please the court?
Yes, please.
Why were comprehensive medical assessment, including CBC and MRI scan, not conducted before launch and only completed basic medical tests? Are you aware that astronaut must do a full body medical examination? Also, why was the decision to proceed with the launch implemented before receiving the PCR test result, despite the risk to the health and safety of both passenger and crew? And also, the council said that the green light signal came getting after every medical result, right? So how about the PCR test? Did you got that? You got only the lateral test, which is not that accurate. And I just want to know that a nurse advice is enough for this passenger, or for this travel. The passengers are going to space and not to Dubai to Sharjah, so they must have to conduct a thorough examination, which they didn't do. They have only they have only conducted just I mean, why couldn't they just ask the doctor as well? Because the nurse who conducted the examination on the day of departure was hired on a short notice from a local outside company in the DIFC.
Your Honors, if you permit me, I can answer to the rebuttals made.
Just a second. Counsel for the claimant, can I confirm that that is the end of your rebuttals? You have nothing else to say?
Yes, Your Honor.
Perfect, thank you. Yes, Mr. Counsel.
Your Honors, in responding to the first rebuttal made by the counsel for the claimant, that why were the medical tests were not exhaustive enough? Why was the MRI scan not done? Again, pointing out that the clarification is very clear that what all tests were done. If you look at the medical tests done by my client, by the medical team of my client, they are more than enough for a person to go even to the astronaut, even to the moon. So a physical examination by the nurse, cardiovascular assessment including ECG, spirometry test, vision test, general psychological test, blood pressure test, blood sample was taken. So CBC test already is taken again to be taken into the consideration. The blood sample was taken, which included all the blood tests which are under the blood test. So CBC comes under the blood sample. A urine sample was taken. So urine sample includes so many other tests like kidney test, liver test. So these were the tests which were exhaustive enough. MRI and CT scan are the tests which are only done if you have an outside injury to the head, or if you have an outside injury to the brain, or if you have a severe headache. She had the severe headache, but she did not inform us. Had it been the situation that she informed us, we might have done the MRI and CT scan also. It was not something big deal for us. We were taking to the moon and we were doing a one-time experience for the claimant. So we would not have compromised in that, first of all. Second, that why was the green signal taken after the why did not we wait for the PCR test result for the green signal? So again, pointing out, it was the decision by the medical personnel. The nurse was the medical professional experienced with 10 years in Emirates testing skills, and she was the person who gave a green signal and who And it is very clear from the statement of facts that it is statistically sufficient statistically to rule out any serious risk that passenger had COVID-19. So it was statistically proven that the test which is already done and the lateral flow test is already enough to determine whether the COVID-19 is positive or negative. So had it been the situation that that's a very inaccurate test, we might have waited for the PCR test also. But just to wait for the PCR test and all medical checkups are when already giving a green signal to grow was according to us an injustifiable. And again the third rebuttal, that how is the nurse sufficient enough to determine the medical test. Again, I would like your honors to attention to the clarification, the last clarification about the medical doctor and the nurse. The doctor is already qualified enough, and she is the retired medical officer from the NASA, under whom the nurse was hired for subsequent days, and previous for which she already had the 10 years of experience. And if you look at the test done by the doctor and the test done by the nurse, the test done by the doctor already includes the test by the nurse. So, or whatever the situation, whatever the tests were done by the nurse were not that technical enough that it should be only done by the doctor. When the doctor was the head, at the same time also the nurse was taking the test. So these are not the tests which only the doctors can do, but under doctor also the nurse was doing the test. Hence, I submit to the rebuttals also. Thank you.
All right. If no further questions at this stage, then should we have the junior counsel for the claimants, please?
I do not have any further question, and it was a great honor for me to argue before this call. Thank you.
Who's next?
Do we have the junior counsel for the claimants? Yeah, I can see the
Yes, yes, ma'am.
All right. Please proceed when you're ready.
Yes. All right. Am I audible?
Yes.
Yes.
Yes. So I'm in front of the Honorable Court to present on basis of the appellant team. All right. The second issue is breach of contract. According to section 1.2, 2.4, and 3.3 of the agreement governing this.
May I please pause you there?
Sure.
I take it that you mean claimant, not appellant, right? Because am I mistaken in assuming that you're before the DIFC court of first instance, or are you before the court of appeal?
I'm in the court of the first instance, and I'm appealing for the claimant.
So not the appellant then?
No, sorry, claimant.
All right. Please proceed.
All right. So, as provided by the Space Flight Companies Agreement, according to Section 1.2, 2.4, and 3.3 of the agreement, it is written clearly that they could postpone or reschedule the launching date in any circumstance which is beyond its control. So it was possible for them to postpone or maybe extend until they get the result of the PCR test. As we all have gone into the COVID scenario, we know even if you want to travel from one country to another country without a PCR test result, none of the airports or any of the flight let us go inside. But a reputed company, a Canadian space flight company with a track record of 4 successful flights in last 3 years, they gave a green light to go to the space without having a PCR test. This can be considered as breach of duty of care. As a commercial space flight operator, they have a duty of care towards the safety of the passenger. They consider the launching date more important than the safety of the passenger. Moreover, the provision empowering the Solar Dream Incorporate postponing or rescheduling the launching date can be considered as the unforeseen circumstance which they have breached. In the case law of Hardle and Anor versus Buxton and Oars, it's a leading English contract law case. It sets the leading rule that the breaching party is liable for all the losses that the contracting parties have been foreseen. It is foreseeable for the Solar Dream Incorporate that sending a passengers without a suitable PCR test would carry a risk. This
But
can be also
don't you think, counselor, while you posing, don't you think that had your client disclose all the details about her health state, about the headache, about tiredness, about everything she is experiencing or was experienced, it would be taken into consideration while taking the decision by the defendant whether or not to launch the space mission.
all right. So as we can see in the facts, it's clearly stated that the mission failure reason or the reason because they came back prematurely is because of the COVID-19, not because of the headache. And this Artemis have been suffering a headache for past 5 years. She has no symptoms due to the head pain. As an individual, every human suffers head pain here and there. And it was only chronic head pain. She wasn't suffering every day, every night. It was just chronic. It comes and goes in between. And it was not something that to be considered very big illness. But as given in the contract, she has undergone all the medical conditions, all the medical uh, given by the nurse, by the doctors, by Saurabh.
Thank you.
Is there any further questions?
I think you can go ahead.
No, Council, I have a quick question for you.
Sure.
Article 4.5 of the agreement established a limitation of liability on the operator, cap it to 1 million. What is
Yes.
your comment based on your, let's say, damages that you are asking for?
Yes. The prayer will be led by my senior counsel, Ms. Raifa. So I will forward this question to Ms. Raifa.
So you are not able to answer to this question, you yourself, you are one team.
All right, it's fine. Okay, so our prayer would be to get the sufficient justice to the Artemis. $1 million is actually not sufficient because she have already paid up to 7.5 million. But as per the contract, we respect the contract, and it's also mentioned and 4.5 of the contract, the limit to the maximum is USD $1 million. We respect to the contract, and we request for at least $1 million to be provided.
Okay, you can proceed.
And to build on the question of my honorable colleague, what is your position with respect to the remaining 2.5, right? Because she paid out of 10 million, she paid 7.5, and that's what you are claiming back now. What about the remaining payment that you still owe to the company, to the operator?
It was mentioned that once they reach back safe, they can provide the remaining amount. But this operation was not a success. It was a failure operation. They have been prematurely before the date that they have promised.
So, in other words, you are asking the court also to basically to that the contract is I don't know, cancelled, and this payment is not more
Yes,
okay,
valid anymore.
Thank you.
Should we have the junior counsel for the defendant, please?
Yes, ma'am. May I ask, am I audible and visible?
Yes, you are.
Thank you. May it please the court, I am part of team Gujarat National Law University appearing on behalf of the defendant in the case before the court today. Over the course of the next 17 minutes, I will be presenting the submissions pertaining to the counterclaim. Ms. Ashrodhya is liable to Solar Dream for breach of contract since she failed to fully disclose the medical conditions mandated by the clause 5.2, 5.3, and 5.5. To support the contention, the counsel shall be presenting with three arguments. First, I'll be explaining the structure of the argument. Argument 1, that headaches constitute a potential medical illness that can affect the participant's fitness to participate in the flight. Second, not informing about the changes in the conditions and not promptly reporting her worsening conditions constitute a breach of contract. And third, Artemis is liable for misrepresentation for not fully disclosure of the facts. If the judges have no preliminary question, then may I ask the permission to begin with my submissions?
I think my preliminary question would be, the claimant said that they are fine with $1 million. How can you respond to it?
So if they're fined with $1 million, we still think that the claimant are the ones who are guilty in this party and they're still liable for the breach of contract. So they should be paying us the damages that we require.
Okay, thank you.
May I proceed?
Yes, please.
The first argument, headaches are recognized as a potential medical illness that has the capacity to affect a participant's fitness in order to participate in a flight. Artemis, by failing to disclose her long-standing issues of headache, long-standing, that means 5 years, has breached clause 5.2 of the agreement, which was explicitly stated by the agreement that you have to disclose. In order to support my contention, I'll be presenting three main things. First, that the US branch of Social Security, in its Social Security ruling, that is a series of presidential decisions, has also stated that headaches are a primary disorders that are recognized as a medically determinable impairment, due to which even in other countries special provisions are provided. Second, as per the WHO report, headaches are ranked as the third leading cause of impairment, which can be followed by a stroke or dementia. Third, according to the Family and Medical Act, which recognizes migraines as a serious health condition and also recognize the need to provide provisions for them. This all shows that headaches can have a profound impact on a person and that needed to be disclosed in order for my client Solar Dream to proceed further. Headaches are known to cause problems and they should have been told to us. In this, I have two main judgments. First, Alexander versus Beijing Co. and Patton versus Paris Henry County Medical Clinic. In both the cases, this was analyzed that headaches do constitute a condition that has the possibility to affect your workplace fitness. By workplace, it will be a normal office hours condition, but we can recognize that if something has the capacity to affect your workplace fitness, it may also have the capacity to affect when you are going for outer space flight. Moving on to the second argument, Artemis' condition started worsening from the pre-flight quarantine period, that is from 14th of February, which she failed to disclose. Thereby, she was breaching clause 5.3 and also contravened the obligation which was imposed by the clause 5.5. It is very clear from the facts that during the second week only, she began suffering from a chronic headache, which continued till the date of the launch. In addition, she was feeling tired during this day too. This constitutes a negligent attitude on part of Artemis, where she was contractually bound, firstly, to disclose, secondly, to tell any worsening condition, both of which she failed. Thereby, she breached 2 and 1, 3 clauses of the agreement. The negligent attitude of Artemis towards her illness hampered the safety of not only her but all the passengers in the flight. She breached the clauses of the agreement which had to be mandatory followed. Hence, Ms. Ashrodhya is liable for breach of contract. Lastly, Artemis misrepresented her exact state unknowingly did not disclose the facts. Her failure to disclose them when explicitly asked to provide any medical conditions in the list of impairment that you have to write, and even in the examination done by the nurse, has affected the flight. This omission led to Solar Dream to believe that Artemis was fit for the flight, and that's why Solar Dream did not conduct any other necessary test that needs to be conducted, because she did not disclose the preliminary thing that was required. As per Article 23 of the Law of Obligations of DIFC, it is stated that if an opinion is accompanied by an incorrect statement that leads to the opinion being true, it constitutes as misrepresentation. This misrepresentation shows that Artemis cannot be said to have acted in good faith when she did not disclose her actual condition. Artemis knew or at least had the presumption that maybe the flight will help her in relieving her of the condition, and also thought that this would increase her popularity in YouTube, through which her sales can increase tremendously. Knowing all the benefits that a flight may give to her and the advantages that the claimant can receive, she deliberately did not disclose the fact. She also feared that if she did, the authorities would not allow her to participate in the agreement. This shows that she knew the intensity of the headaches and had the capacity to disbar her from the space flight. This shows that Miss Astrothia did not act in good faith but for her own profit. Artemis Astrothia's failure to disclose her chronic headaches during the medical evaluation constitute misrepresentation and an omission on her duty, as it led Solar Dream to believe that she was fit when she was not. Her misrepresentation constitutes a breach of contract, and hence she should be liable.
Counsel, just a quick question. I understand where you're coming from and this point you've made about breach of contract, but your client was also to a certain extent negligent in allowing the flight to take off without waiting for the PCR tests. If you notice, your co-counsel, the senior counsel, did tell us in his submissions that the reason that the flight got cancelled eventually was the COVID test and not the headache. So therefore, it is your team's position that it was actually the issue with you not waiting for the PCR test, which is what led to the flight cancellation.
We recognize that we did not wait for the PCR test, but as we do know, no prior information was made to us. The quarantine period was successful in determining whether a person had other symptoms or not, and even all the lateral tests did come successful, and there was no possibility, at least there was a very measured possibility, that COVID variant may be infectious here. And this waiting for a single PCR test is not reasonable enough for a whole flight, which had the flight needed to be launched on specific dates and specific meteorological events. Just because a PCR test was not available, we could not have waited, and therefore we took the risk of launching. If we had known that any symptom was available, we would have surely delayed the launch, but in this case it was not possible and not beneficial for the entire flight.
Counsel, I have a quick question for you. You know, as an operator, and before the launch, you have to get an operation license from the, let's say, from the agency in UAE, because the launch have taken place from UAE, and the regulation for space flight are applicable. And I think you have seen that in the Moot court problem. One of the requirements in the regulation is that the operator should provide an evidence that the participant is fit physically. Did you what type of evidence that you have presented to the, let's say, the agency here in UAE before the launch? And if so, that means you have 100% show that the participant is fit physically.
Yes. So, in order to answer your question, I would like to go back to the clarifications that are given to us. So, the doctor conducted on every single participant a series of tests that include 2 times examination by the nurse, all the lateral flow test, blood pressure test, vision test. I would like to point out that this period was only a 1 week duration. So all the participants were going for a 1 week duration. That's why a series of tests that are needed, that can, all the things that can medically go wrong were taken in place, and that's why cardiovascular assessments, ECG, vision test, blood pressure test, all these things were taken, and they were sufficient enough to determine whether a patient was fit or not for a 1 week travel. In addition to that, we asked for a question, we give a list of impairments that every participants had, and on the basis of that we could have conducted an external amount of tests in addition to the given list that was provided to us. Since we did not know any other symptoms for our claimant, we did not proceed with any further test. Instead, stick to the list of tests that are mandated by the authorities in order to make sure that the 1 week travel would be safe and sound. If the travel would have been for, like the claimant pointed out, in case of astronauts, since they go for a longer period of time, a more thorough analysis of checks and procedures are done. Since this was 1 week travel, we asked about full disclosure, and a series of tests were conducted. That was sufficient enough.
Thank you.
A quick question from my side, Councillor, if I may. How she got this COVID-19? That's my question. Because 14 days quarantine, after, if this quarantine is handled properly, it's almost zero chance that a person could get COVID-19. So how this happen? That's my question. How then she can get COVID-19 after 14 days of quarantine?
Yes. So according to all the informations that are provided to us, I'll just like a minute to go through the Moot problem. So the variant in this condition spread much more faster than the previous and became symptomatic within 5 to 10 days. So within the period of 15 days, we would like to say that within the period of the 15 days, she was asymptomatic, and that was not informed to us. She then, by time to time, developed the headaches, and even she became weaker in her conditions. That's why the COVID-19 variant is a faster variant and a much new variant, which could have been contracted in various other ways that are not determinable for us. Since this is a new disease that came, we are not responsible for every single disease that spread. The virus has the possibility to spread very easily. That's why she contracted that.
So just to clarify, is this your position that she already got COVID prior to arrival at the quarantine station, and she was infected for 14 days, right? Is that correct?
No, we are saying that after the 14 days, she has the possibility that she could have been infected.
Okay.
Because if in the quarantine period she would have been infected, then we could have determined that.
Okay. Thank you.
Thank you. If there are any further questions, I'd like to address that. Otherwise, we'll be moving on with the prayer. I'll presume that there are no further questions. Moving on to the prayer. In the Dubai International Financial Center courts, the court of first instance, we, the defendants, respectfully pray to dismiss the claims by the claimant in these conditions and award Solar Dream damages for Ms. Ashothia's breach of the spaceflight agreement, including all the things and the additional clause, and declare that Solar Dream acted reasonably and in accordance with all the procedures. Thank you. I'll respectfully submit my submission.
Counsel, quick question, sorry, from rising from your prayer.
Yeah, sure.
Are you also claiming for the 2.5 million balance payment that is owed to you under the agreement, in addition to your damages claim?
We would like for the claimant to fully pay us, but if she agrees to pay us the full damages that we now require, we would be fine to forego the 2.5 million payment.
So you're giving up your claim for the 2.5 million,
We would be fine with giving up the 2. If the
even though
damages,
it is your position that she breached the contract and you were not in breach.
we recognize, but we'll be foregoing the 2.5 million claimant, recognizing that the damages are given to us, and that will be fine for us.
All right. Thank you so much.
Thank you. It was an honor saying before this call.
Can we have rebuttals from the claimant?
Am I audible?
Yes.
Um, if you're looking into the dates, it's mentioned that on fact number 9 that from second week she has suffered from her headache. It comes between 4th to 10th of February. So the high chance for her to get the COVID is while in the quarantine. If they were also giving a proper medical checkup while in quarantine, it was easier for the medical team to recognize it because having COVID, they have a lot of other symptoms as well. Why did the medical team fail in recognizing this during the COVID time, quarantine time?
I seek the permission for the rebuttals.
Sorry, just a second. Counsel for the claimant, is that all your rebuttals? Do you have anything else to say?
That's it, ma'am. That's all I have to ask.
Thank you so much. Sir, rebuttals, please.
Just a moment. Respondents, how many minutes do you have for the rebuttal? For the sorry rebuttal, sorry?
I have reserved 5 minutes.
5 minutes. Okay, thank you very much.
As for the claimant, she contends that Artemis may have contracted the disease in the second week, but the headaches are a part of Artemis's lifestyle. Now, she has been suffering that for the past 5 years, and it is very much probable and possible that during the quarantine period, she suffered from headaches that are part of her daily lifestyle. Whether she contracted COVID-19 in this part or not, we are denying that, because if she had contracted in COVID-19 in the quarantine period, that could have been determined by the Solar Dreams facilities. Between after the 14 days quarantine period, there was a layover in New York. It is possible that since the COVID variant spread so fast, she has contracted the COVID-19 in that period, that is the New York layover part, and not the quarantine. Are there any further questions? I'll like to submit my rebuttals.
Nothing from my end. Do any of my colleagues have any further questions?
No, nothing from my side as well.
Not from my.
Thank you so much for the opportunity.
Or should we wait for the feedbacks?
I think let the judges go back and confer a bit, and then we will come back to you.
Oh, we'll wait in this courtroom only.
Yeah, that makes sense. But in the meanwhile, could I trouble you? I'm just going to paste something in the chat box, just so that we have your names etc. all correct. Could I just trouble both teams
Sure.
to give us, if you can see the chat box, I'll ask you to just put in your team name, the senior counsel name, and the junior counsel name for both teams.
Doing it.
Perfect. So I think the judges will go back to the judges' room and we'll come back to you.
If anyone from the admin side, maybe Dipesh sir, can you please tell us that we should wait here only, no?
Yeah, I think so. Shivam, judges are joining. Okay.
Okay, sir. Thank you.
I think we're waiting for Mohammed. Yeah. Sorry, has Mohammed joined?
I don't. Yes, there we go.
Every time I have to go through the.
It's okay. It's good to see you again, Mohammed.
Yeah.
Yes. You are going directly to the moon gateway. I am going just to the orbit somewhere to, yeah.
All right. Do we have all the participants? I can see the defendants, but I'm not sure if the claimants are here.
I think claimants are also here.
Yes, Your Honor.
Okay.
Okay, we are here. Great.
Maybe I ask Mohammed to start with the.
Oh, thank you, Donna. I will be very, very quick because it was a long day. First of all, I would like to thank both teams. You did very well. You know, I'm an old man, old-fashioned man. I don't like the online and this technology. I would prefer to see you physically. But anyway, I have two quick remarks. The first one, by using this technology, sometimes I felt that you were reading. I'm talking about 4 members of both teams. Sometimes you was using either a paper or the screen. So my advice, don't read. You know, you are here doing advocacy skills, so you have to show the ability not to use any. This is the first thing. And I will leave to Ivan and Tamanat. I want you, in doing this exercise, you have the chance to do the remote court. In my time, I remember, I'm coming from the civil, civil jurisdiction. We didn't do so much moot court. So you have the chance to practice law through this exercise, through the moot court. My advice to you guys, you have to read as much as you can. Prepare. I had the chance to practice space law because I have served UAE Space Agency for 7 years. And your space activities are amazing. And, you know, but they are very hazards with the related to these activities. I have heard one of you, I don't remember, saying this is a common activity similar to any other activity. It's not. It's very hazardous, very, costly, very. So you have to take this, activity seriously. And final point, I hope that some of you will maybe take some, maybe a master degree or practice space law. If you decide to do so, I will be here to help you. Thank you. The floor is yours, Taman.
Oh, that's wonderful. I wish I had someone when I was mooting like you, as supportive. Ivan, do you want to follow on?
Yeah, I can. A brief introduction about myself. My name is Ivan, working as legal counsel at Adidas. And as a hobby, moot courts are actually my hobby. I've served as a coach and as a judge for many different competitions, including the JESOP competition and Telders competition. So this round was quite interesting. And I would like to echo on what Mohammed mentioned. Thank you very much for your time, for the hard work in doing your preparations to this round. 2 remarks from my side. First one is we are not in the. Remember that we are not in the mooting room. We are in a moot courtroom, which means we want to hear from you the law. We need to hear from you the cases. And all the statements you have to support with the relevant law and the cases. And this is one of the grounds of how we will judge you in the score sheet, right? And this is very important. Don't wait for the judge to ask you, hey, what are the cases? Like, mention these cases. And this, by doing this, you will show to the court that you know what you are saying, and this is supported by law. Second remark from my side, very important as well. You have and this is for both sides. You have the submissions, which means you are asking the court for something, and you cannot change it, right? You cannot change it. Oh, by the way, it was 7.5, now it's 1 million, right? You cannot. Like you need to find the arguments, and if this if this happens in real life, your client would kill you. How come it was 7.5 out of a sudden it's 7.5 million? And then same is applicable to the defendants or respondents. Like, if she agrees to pay 5 million, we will waive this 2.5. I mean, where it is stated in the facts? How can you explain this to your client? Oh, by the way, we won the case, she will pay 5 million, but this 2.5, we decided to waive it. I mean, you don't have this authority as a lawyers, right? So always look into the facts and then stick to the arguments. With respect to this 2.5 remaining payment, Your Honors, we don't know. This is not part of this proceeding. We don't know what the fate is. Potentially, our client would want to proceed with the court, but whether or not, we don't know. This is not part of this proceeding. And then for the applicants, of course, you need to find the arguments why this clause is not applicable. This is very simple. But overall, it was very interesting, and I enjoyed the round. Thank you very much.
Thank you. So just to add on and to give you a brief introduction, I'm Damayanti. I'm an off-counsel with Fishtay & Co., which is a law firm based in Dubai. We do primarily shipping law, but I have personally an interest in space law because it is, and during my university, I have done the Manfred Lachs Space Law Moot Court competition. So, it's a pet project of mine. In general, yes, I would like to add on and say thank you both the teams for being here and giving us this wonderful opportunity to judge you. I think both my colleagues have said mainly what there is to say. I would just add two things. The first is, when you're coming in for a moot court competition, we expect to see the very best arguments that you have, which means that before you come in front of us, we expect that you will have had at least a few rounds of preparation, practice, etc. So what we get is not just your bare arguments, but arguments which have been refined over a few rounds of practice, right? So I think confidence and preparation are key for such competitions. And as you will see, when you start your professional career, this will help you to also prepare for if you ever do go into litigation, advocacy, etc. The more you prepare, the more you read, it helps you in structuring your case better. And the second is in terms of when a judge asks you a question, right? I think it's very important. I understand, as having been a mooter, I understand how difficult it is to maintain, your poise under pressure, especially if you have a prepared speech and, the flow of that speech gets broken by judges asking you questions. But always take a breath, think about why the judge is asking you what they're asking you. So most of the times when a judge asks you a question, it is to point you to something that they want to hear. So I know it's more difficult to do than for me to say, but think about what the judge is asking you, and you have to start thinking on your feet, right? So say if someone asks you, will you give up your claim for 2.5? You must think, well, what is the reasoning behind asking this question? So, but except for that, it was a great experience, and thank you both the teams.
Thank you so much for the feedback. It was also a great experience. Thank you.
Thank you.
Thank you.
Can we leave?
I think so. I mean, I have nothing else from my side.
That's it. Thank you very much.
Thank you all.
Best of luck.
Best of luck to you guys for the next rounds.
Thank you. Bye-bye.
I guess Mohammed is speaking something, but he's on mute.
You're on mute, Mohammed.
You need to unmute yourself.
We can't hear you.
Damayanti,
Yes.
It's difficult to go to the judge's room, so I want you for 1 second. After
Okay, all right.
Yeah.
All
You
right.
will leave.
Yes.
Yeah, I think we're alone.
Yes, I will be very brief. Ivan and
Right.
Damayanti, it
Yeah.
was great. Opportunity for me to know each of you. Both of you I've sent you an invitation on LinkedIn just to keep in touch. So please accept it.
Oh, definitely,
Sure,
absolutely.
definitely.
It was
Thank
a
you.
great meeting.
I have been working for. I've tried to bring the Moot Court, the international space law, that you participate in to this.
The Manfred Lacks, yes,
You
yes.
mentioned that, but unfortunately I couldn't. If we can work all together to bring it to the region,
Of course,
it would be great.
that would be great. Absolutely, yes, definitely.
Because I am a member of the International Institute of Space Law.
Yeah.
We have great friends that can help us to bring it to the region.
Absolutely, I'd be glad to help you with that.
I want you with us, Evan.
Yeah, I'm with you.
Thank you.
Thank you very much.
Yes, bye-bye.
It was great meeting you both.
Thank you. Thank
Take
you.
care. Have a great day. Bye.
Bye bye.
Bye-bye.